Hello and welcome to the fourth and final webinar in our autumn-winter webinar series, where we will be talking about enforcement in financial remedies proceedings. I'm Catrin Howells and I'm joined this evening by Hannah Justiva. We are both family barristers here at 42BR Barristers and we both specialise in private family law. Any questions that you have, we'd be grateful if they could go into the Q&A box and they'll be addressed at the end of the session if we've got time, or they'll be followed up via email. Just so that you know, an email containing the recording, a feedback form, and the slides from today will be circulated by email within the next week or so. The recording will also be available on our website, 42br.com, and on our YouTube channel. So let's start this webinar by going back to basics slightly and thinking about what parts of a financial remedies order are enforceable. So it's worth noting at this stage that recitals imposing an obligation can be enforceable to the extent that the court has jurisdiction to make an order in those terms. So I've put the case of H&H on the slide. In that case, there was provision for maintenance, which was made in the recitals, and in that case, it was held to be enforceable. The next part of orders that it's also worth mentioning here is undertakings. Undertakings for the payment of money may be enforced as if it were an order under Part 2 Matrimonial Causes Act 1973. So that's the type of enforcement that we're going to be talking about in this webinar today. For the undertaking to be enforced in this way, it must be endorsed by a penal notice. I do note that the standard orders would provide for this anyway. I've also said on the slide there that undertakings other than for the payment of money are to be enforced as a contempt of court under the Family Procedure Rules, Part 37. Again, that does require that the undertaking is endorsed by a penal notice. Part 37 is beyond the scope of this webinar, as it could be the topic of a whole other webinar. The rest of this webinar will be focusing really on enforcement of substantive orders. I've put on the slide there the full Section 32 of the Matrimonial Causes Act 1973. This tells us that permission of the court is required to enforce any arrears that fall to be paid more than 12 months before the application to enforce is made. It is worth flagging at this stage that this applies to payment of a lump sum or periodical payments, including maintenance pending suit. The case law tends to focus on enforcement of maintenance arrears, but it is worth bearing in mind that a financial provision order, and I've underlined that on the slide there, that does include an order for a lump sum, and that's as defined in Section 21 of the Matrimonial Causes Act. You can also see at the very bottom of the slide, subsection 3, it says that the procedure for applying for permission to enforce arrears beyond 12 months should be prescribed by the rules of court. It has been noted in the case of Tattersall and Tattersall that there is no prescribed procedure at the moment for applying for that permission. Sticking with enforcement of arrears, there is a starting point set as noted in B and C, which is a 1995 case. The starting point is that arrears over 12 months old are not enforceable. I've put that quote up on the slide, but I would warn you to be aware that the court also stated in this case that the applicant must prove special circumstances in order to enforce those arrears over 12 months old. This has been doubted by later authority. It is perhaps safer to say that it's fact-specific as to whether a court will allow enforcement of arrears accruing more than 12 months ago. I've also included on the slide an unreported case of Lumsden and Lumsden, and that is a Court of Appeal case, if I remember rightly, which says that in exercising the discretion, courts should have regard to the culpability of the debtor, the debtor's means to pay, and any steps the creditor has previously taken to enforce the outstanding sums. And now I'll hand over to Hannah.
Thank you. So I'm going to talk a bit about orders for sale. And we wanted to deal with this before going into, if you like, the typical enforcement orders that you might think of, which we basically borrow from civil law. So the reason orders for sale is so important to think about in terms of enforcement is by far and away, orders for sale is probably what we're all using day in, day out to make sure financial remedies orders are enforceable. And of course, one thing that you always want to be thinking about from the very outset, really, of proceedings or pre-proceedings is how are we going to enforce this? Because sadly, of course, it is a question that we need to bear in mind. And normally, the way that you're going to make sure that your client is able to get the amount of money that they should be getting under that order is by selling property. So normally that would be the family home. That's why we always have the default orders for sale within final orders when there's a lump sum. It's just something that you need to be very familiar with. So on the slide, we've got where the power comes from. Just to flag that, strictly speaking, in order for the court to make an order for sale, the court does already need to have made a lump sum order, a secure periodical payments order, or a property adjustment order. And just to flag that, I have had experiences with judges who, for example, let's say it's agreed that really the only asset is a family home. And the question is, what's the appropriate division of the equity in the family home? You have your order for sale in your final order, and then the net proceeds split appropriately. But I certainly have several judges flag that actually we also need separately a lump sum order, even if it's basically to confirm what's in the order for sale, and we're not trying to duplicate that. But just to be aware, strictly speaking, you will need one of those orders as well. And I would always say it's better safe than sorry in case there are any issues with enforcement. The second quote, if you like, on the slide is just to kind of remind us all that it's in the statute that in terms of, for example, whether you have joint conduct of sale or sole conduct of sale, the court is able to make consequential orders around an order for sale. And inevitably, if you do have a case where this becomes a problem, so classic example is the party who is living in the property as their home. There's been an order for sale made in respect of that property. They are not particularly happy about that, and though understandable, there is the order. And they may be not accepting offers when it's reasonable to do so. I've also had cases where they've been disruptive and even abusive towards estate agents, towards prospective viewers. You can make your application to, in particular, ask for sole conduct of sale so that your client can unilaterally accept offers which are appropriate. So the court's able to make all those kinds of orders. The other thing to bear in mind is that if you have an order for sale against property in which a third party has an interest, they're going to need to be able to make representations about that. So it's just something to be alive to if that's an issue in your case. Before kind of moving on to other orders that I'd encourage you to consider if you are having issues with enforcing an order for sale, in terms of the evidence that you can put to the court in support of your application to enforce that order, estate agents generally are extremely helpful because they want it sold. They want the property sold. They can be normally, I found they're very willing to put in writing any issues they've experienced. I've also had cases where photographs, even videos of inappropriate behaviour towards them and prospective viewers can be attached. So I'd say if you're looking for evidence, and you will need it in terms of your enforcement application for this, they are really an excellent resource and probably your go-to. That brings me on to order for possession. If we go back to that kind of classic example, we have a party living in a property, it's their home and they're being disruptive. You also need to think about the fact that you're going to need to sell this property with vacant possession. And therefore, in all likelihood, you're probably going to need an order for possession on top of enforcing the order for sale, because what you don't want to happen is you get your sole conduct of sale, you accept the offer, all good, and they refuse to leave the property, and you can't sell it with vacant possession, and then you have to start all over again. So I would encourage you to apply for an order for possession at the same time as you make your application to enforce that order for sale. The power is in the family procedure rules. It's at rule 9.24, and I've put it there, confirming the court can do this. And in terms of the test to be applied for an order for possession, BR and VT from 2015 confirms it's the same test as an occupation order. So it's a section 33, which, just to review, though I'm sure it's all fresh in our minds, but it's the balance of harm test, section 33, subsection 7. But probably more realistically, you're looking at the discretionary test. So that's section 33, subsection 6. So that's housing needs and resources, financial needs and resources, health, safety and well-being, and conduct. And just make sure that when you're putting in a statement in support of your application, you're also addressing all of those points that you would as if it were an occupation order application, to make sure that the court has evidence in terms of why it should make an order for possession. Although I think it can feel somewhat necessarily extreme, but certainly quite a strong position to take. I find that in my experience, judges have been really receptive and really alive to the fact that you're going to need vacant possession and are quite willing to consider and make orders for possession in these kinds of cases where, unfortunately, a party is not complying. Just for context, so you make sure that the order says order for possession, the standard orders will provide you with the correct wording. What then happens is that can form the basis of an application to the county court for a warrant of possession, and that will then allow bailiffs to take physical possession of the land, and that's how it's enforced. So it's quite a useful provision to be aware of. The other one linking to your orders for sale, which is probably a bit more familiar, is the execution of documents. So this comes from the section 39 of the Senior Courts Act 1981. This can be useful, obviously, not just for sale, but also a transfer in terms of property. So it's if there is a document or documents that the other party needs to sign, and for whatever reason, it's just not happening and they're not signing those documents. The court has the power to nominate a person to sign it. Normally, that would be a district judge. Just to flag, in case you have quite a pedantic court that you're dealing with, the court isn't signing the document on the non-complying party's behalf. It's being signed as if that person had signed it. In terms of the approach, if you do have the situation, you just want to refer back to basics, the case that sets out best practice in this is Welch and Welch, which is on the screen now from 2017. It just sets out that you need to invite the other party to please sign the document. If they refuse or just neglect to sign that document within a certain period of time, then you apply to the court on notice, providing a statement evidencing that failure. The court then needs to make an order for the party to sign the document, warning if they don't sign, an application may be made without notice for the court to sign it pursuant to section 39. And then you can, if they continue not to sign it, then you make that without notice application supported by evidence, and then the court will make the order. If you are in proceedings and in a case where there has been really poor engagement from the other side, whether they've just not engaged at all with the proceedings, or if their engagement has been inconsistent or quite limited, I think it certainly would be fair to flag this to the court on the making of the final order in the substantive proceedings, that can we please have an order that they need to sign any documents requested of them within so many days, 7 days, etc., just to try and fast forward, if you like, those steps and make it a bit easier. So now I'm going to hand back to Catrin to talk a bit about procedure.
Thank you. So you'll see I've put on the slide there, Rule 33, well, the bulk of the rules on enforcement in financial remedies are found in Part 33, the family procedure rules, and I've included the first part of Rule 33.3 there on the slide. In particular, let's look at sub-rule 2, A and B, which says that there can either be an application for a specific method of enforcement or such method of enforcement as the court considers appropriate. This is sometimes referred to as a general enforcement application, and that's what we're going to be looking at on this slide. So that's that same rule 33.3 just continued. So we're down onto sub rules 3 and 4. These applications can be useful where you don't know much about the respondent or the debtor's current resources, and therefore which method of enforcement is going to be most appropriate for your case. The application is made on a Form D50K. On issue of this application, the court will normally make an order for the debtor to complete a Form E1 and file that with the court. I'd note that this is a change in procedure. I can't quite remember as to when that change was made, but as perhaps we're not dealing with enforcement applications all of the time, it might be a change to when you previously dealt with a general enforcement application. So I've said that the court on issue will make that order for the Form E1. There will also be an order for the debtor to attend court for questioning on oath. There does exist a standard set of questions to be asked by a debtor by a court officer. So legal representatives aren't limited to those questions, of course, but I would say they might be helpful as a starting point in straightforward cases. So those standard questions are found in Annex A to PD 71 of the Civil Procedure Rules. It can also be found, it's Form EX140 on the .gov.uk website. Like I said, you're not limited to those questions, but say you have a scenario where that Form E1 hasn't been filed, it can provide you with a basis for that information that you might need and the court might need in order to determine which method of enforcement is going to be the most appropriate in this case. I've mentioned that there's a requirement for the debtor to attend for questioning. A penal notice must be attached to the requirement to attend. We can see that on sub rule 4 at the bottom of the slide. On an application such as this, the court, as I've said, will make such enforcement orders as it considers appropriate. I would, however, flag that there is no ability for the court to order a judgment summons. Any available method of enforcement may be used, apart from a judgment summons, and a judgment creditor may use more than one method. Hannah, in a second, will be taking us through those different options. But just before we get there, a word on what I've said is subparagraph 2A, which is a specified method of enforcement. So I've brought back up FPR Rule 33.3. There is always the option of applying for a specific method of enforcement. For example, you know about certain assets and you have a particular remedy in mind. The relevant forms will be particular to the remedy sought, and it will be Hannah who's now going to take us through some of the available methods.
Yes, so these are the various, if you like, traditional, when we think of enforcement orders, and I'll also just take you through, if you know exactly which of these you wish to apply for, what the form is and the process of doing that. So charging orders. So charging orders comes the power to charge, to have a charge over a property or security, is from the Charging Orders Act of 1979. On there, on the slide is section 1, that's where the power for the court to charge assets comes from. And then what you'll find in section 2, again on the slide, is what kinds of assets can actually be charged. They basically fall into 2 categories. So the first one is land or property, and the second one is securities. So when I say that, I mean things like stocks and shares. The reason it's important to know which asset you want to have a charge against is because it's a different form. So for land, it's an FE6, and for securities, it's an FE7. In terms of the procedure, you go to the Family Procedure Rules and it's part 40 and Practice Direction 40A, and it sets it out quite nicely. So the process is you make the application on the relevant form and you make that application without notice. What then happens is the court will deal with your application on the papers without a hearing. And at that stage, it will either make an interim charging order or not. And then also fix a hearing as to whether that interim charging order, if made, should be made final. The person against whom the assets are to be charged has the opportunity, obviously, to respond thereafter, and they must provide any evidence they seek to rely upon not less than 7 days before that final hearing. And then at the hearing itself, the court will determine whether that charging order should be made final or not. Obviously, the reason that you're able to make it without notice is you don't want them to go and dissipate the asset. So if you do know this is the remedy that you're seeking, this is the order, the route you're going down, there's potentially that benefit to making it directly rather than under the general provision. Just to flag, this only has a charge against the asset. You will also, in reality, need an order for sale. So you secure that charge, and then you're going to need the order for sale to actually get your money. So that's charging orders. The next option available, which might be quite useful, is third-party debt orders. Now, for this, we're going into the Civil Procedure Rules in 1998. You're looking at Part 72 and Practice Direction 72. These provisions are incorporated into the Family Procedure Rules by Rule 33.24, just to make sure everyone's happy that we can look at these in terms of family proceedings. So the point of these orders is, let's say, for example, that a third party, most typically a bank, owes money to the debtor, so to the person who hasn't paid. Rather than have them pay the debtor and then try and get the money from them, given there's obviously been difficulties doing that, is just asking the third party to pay the creditor, so the person who's owed the money, to pay them directly. Saying one example is bank accounts. It could also be things like director's loan, really anything like that. In terms of the procedure, it's actually quite similar to how you would go about applying for a charging order. So you apply again without notice, again for pretty obvious reasons that you don't want them to suddenly move that money. It's dealt with without a hearing, and the court may make an interim order that the third party must not reduce below a certain amount the money that they owe to the debtor, and then the court will also fix a hearing. If the debtor objects, they can, again, obviously file and serve evidence, and they need to do that no later than 3 days prior to the hearing. And then at the hearing, the court considers whether to make the third party debt order or not. The form that you need for this particular order is an N349. In terms of other things just to be aware of with third party debt orders, just be careful with joint accounts. You're going to have issues, and really what we're talking about is accounts of their sole name. And also just to flag, a third-party debt order can't attach to a pension, so not a pension fund or a SIP. But what you can do is you can get an order for the debtor to draw down part of their pension, and then you apply for the third-party debt order, and it can bite at that stage. And the case and the authority for that is Brake and Guy 2022 EWHC 1746 from Chancery Division. So that's quite useful to know. The next one, which I'm sure you probably heard of, is the Attachment of Earnings order. So we look to the Attachment of Earnings Act 1971. That's where we find the power for the court to do this. One thing to be really wary of, if you like, in terms of attachment of earnings orders is what earnings you can actually attach the order to and what you can't. So the Act confirms, and you'll find it in section 24 of the Act, that earnings include, so wages, so if they're employed, it can include fees, bonuses, commission, overtime, all of that. It can also include private pensions. But what's quite interesting is what it cannot be attached to. So this is also in section 24. So the obvious one is if they're self-employed, you're not going to be successful in applying for an attachment of earnings order. But also if they're on benefits, and also the armed forces. There is an exception within the Act in terms of the armed forces. Having kind of looked around a little bit to see if you can do anything if you are in that situation, there is section 342 of the Armed Forces Act, which potentially gives you a remedy, if you like, or an option, and essentially corresponds to the civilian attachment of earnings procedure. But yes, just a flag, if your debtor is employed in the armed forces, you're not going to be able to use this route of an attachment of earnings order. And then also the state pension. In terms of the procedure, the form that you make the application on, so we're looking at the FPR 2020 Part 39, is an FE15. When you file that application, the court will set a date for the hearing, and the debtor will respond in the form of the FE17. Now, the other form that you're going to want, and is best practice, is to ask their employer to complete an N338, which is a statement of the debtor's earnings. Because, of course, the problem is the debtor may well not engage and may not complete their form. So if you're asking their employer to complete the N338, the court at least has that information available and might make it easier for the court to deal with the application in the event the debtor is just not engaging. When you get to your hearing, the court will do two things. So the first thing the court will do, if it makes an attachment of earnings order, is set something called the normal deduction rate. So that is the amount that would usually be deducted from the debtor's salary. The court will also, though, set something called the protected earnings rate, and that is an amount which their income is not to drop below. In practice, the protected earnings rate is always going to be set higher than, for example, what they'd receive if they were on benefits, so that they're not disincentivized from working. And obviously, in this kind of application, what the court's interested in is their income, but also any outgoings, any commitments that you're aware of, which might be particularly relevant if they're just not engaging, just to flag that so the court feels comfortable making that order. In terms of other options, so we have warrant of control. When looking at this potential option, I think, to be honest, it's probably less likely that it's going to be helpful to you. But we're looking at the CPR again, so 1998 parts 83 and 84 and the corresponding practice directions. It's incorporated into the family procedurals by Rule 33.1. What this enables you to do is, if the debtor has a really valuable chattel, so they have something like very expensive, actually a painting or perhaps jewelry or something like that, you can have an order that that item is obtained, and then in practice it would be sold at auction. And the proceeds of the sale from auction would go towards paying the cost of retrieving that item, and obviously then repaying the creditor any amounts they are owed from the debtor. Just be careful in terms of what items can and cannot be subject to a warrant of control. Just very briefly, to give you kind of a flavour of what you might be able to get an order against and what not, is there is once again an exception in terms of the armed forces. So Section 350 of the Armed Forces Act 2006 provides that it cannot be against any weapons or equipment or clothing, etc., which may be used in the course of service of the armed forces. Similarly, the court generally won't be looking at items that the debtor needs for their employment, for their trade, for kind of obvious reasons. Domestic goods are generally not available, anything in terms that's required for care of a child, for a disabled person or an older person, certain animals, vehicles. So just be aware before you kind of make that application. It's definitely something you can have a warrant of control against. In terms of the form, so it's the form 323, and you can make the application without notice, kind of again for obvious reasons. Also, just a slight kind of language point, if you like, you might also hear writ of control. So the only difference between warrant and a writ is a warrant is in the family court, the county court, and a writ is the high court. We're talking about the same thing, so don't worry in respect of that. The next option is very rare, I think it's fair to say. So the court does have the power to appoint a receiver. The court has the power from Section 37 of the Senior Courts Act 1981, and the test is whether it's just and convenient to do so as to whether a receiver should be appointed. Now, a receiver in all likelihood will be an accountant, which then leads into, if you like, the key case on this area, Simon and Wilmot from 2014, that a party should only really apply for a receiver as a course of last resort. And it said for reasons that hardly need to be spelt out. When in a nutshell, it's because of cost. It's so expensive to appoint a receiver. They will be charging appropriate accountants' rates, but it is available And it is something that if there is a significant amount of money that you're trying to enforce, you're trying to get, and you're having real difficulties, that appointing a receiver, having an accountant go through the debtor's finances as much as they can and try and retrieve that money may be your only option. If you do have to go down that route, you're looking at the CPR and it's Part 69. Which then brings me to judgment summons, which of course is not available, as Catrin mentioned, if you go down kind of the general route. It could be an entire different webinar, so we're not going to go through it in any real depth, but just to flag the basics, if you like, so you're aware of what this is and potentially when it might be useful. So judgment summons comes from the Debtors Act from 1869. It is, if you have a situation where money is owed, you can apply for judgment summons. What you need to do is you need to prove beyond reasonable doubt, so to the criminal standard, that the debtor either has or has had, since the date of the original order or judgment, the means to pay the sum owing under the original order or judgment and has refused or neglected to pay. So because it's to the criminal standard, it is obviously more difficult in terms of getting this remedy, and the consequence, if you are successful in respect of that, is imprisonment for up to 6 weeks. Just to obviously flag, the problem with this option is you don't actually get the money, which most clients find a bit of a problem. But it also doesn't mean that then the debt is extinguished. You can still go after the debtor for the money in terms of the other enforcement options available. In terms of the procedure, so that could be a whole different webinar, but just to flag, you're also looking at Part 37 in terms of committal, and really it's not entirely clear to what extent that also applies to judgment summons, but it's certainly considered best practice for it to be Part 37 compliant. So it's there, but probably won't be overly helpful in most cases.
So coming on to some more of the miscellaneous methods of enforcement, and we're starting with Hadkinson orders. So this bars a party from being heard upon an application that they have made. And in practice, this is usually that party's own variation or set-aside application in relation to their financial remedies order. And they are barred until they have complied with an existing order. And now the case law is absolutely clear that this is a remedy of last resort. And I've included the quote on the slide from that's paragraph 3 of the case of Assoon and Assoon from 2017. So there are a number of summaries out there of the principles of making Hadkinson orders, but I do find this summary from De Gafforge from 2018 particularly succinct. It is a Court of Appeal judgment. So I've set out the principles on there on the slide. The first is the respondent is in contempt. That contempt is deliberate and continuing. As a result, there is an impediment to the course of justice. There is no other realistic and effective remedy. The order is proportionate to the problem and goes no further than necessary to remedy it. And I think you can even see, again, from that summary there, these are our orders of last resort. But as Hannah was saying, in terms of the appointment of a receiver, if you're in that scenario, perhaps it's something that you will need to consider. So then moving on to pension sharing orders and the use of those as a means of enforcement. So there was the case of Amin and Amin, the 2017 Court of Appeal judgment, where they approved Mr. Justice Moylan, as he then was, decision to leave open the applicant's pension sharing order claims so that then they could be reactivated if the husband failed to pay the lump sum. I've also included on the slide another reported case from last year. This is Reese Taylor sitting as a recorder at the Central Family Court. The judgment contains some of his concerns about the husband's behaviour during the case, his litigation behaviour, I should say. And he chose to leave the wife's pension sharing claims open. And in particular, that was because the pensions were one of the only assets in this jurisdiction that he was able to make orders about. And this perhaps continues on the theme that we've seen throughout, which is if you have a case, and I think it's easy to see those cases where you can already see that there might be enforcement issues further down the line, it's worth being really careful on the making of that final order, thinking about what you might need to use in future. So, for instance, keeping open the pension sharing order claims, making sure that there's provision for lump sums and order for sale and default, maybe even thinking about making provision for, execution of documents if that's necessary at that stage. And then finally, we do come on to interest and costs. Interest, I'd note, is usually provided for in the standard orders on a lump sum. So this is something, to keep an eye on when drafting your final order. There is automatic interest payable on lump sums under £5,000, and that's per the second quote on the slide, which is the County Court's Interest on Judgment Debts Order 1991. This interest rate is currently set at 8%. I've also included on the slide section 23(6) of the Matrimonial Causes Act. That provides that the court can make an order for interest where it orders for the payment of a lump sum that is deferred or in instalments. Just a procedural point on interest. Where there is any claim for interest on enforcement, it is very important to set out in your statement accompanying the application the amount claimed, the relevant dates, and the rate of interest applied, mainly so the court can see your calculations and why you're entitled to what you say you're entitled to. The title of this slide also indicates that we'll be dealing with costs. The subject of costs could be, and probably is going to be,
Will be.
You heard it here first. The subject of a whole other webinar. So I won't go into too much detail here. But just to say that there is no presumption in the rules as to costs on an enforcement application. The court has a clean sheet. And so what I would say is that it's important to make that application for costs so that it can be considered by the court.
Okay, well, thank you very much for attending this webinar. We hope it's been useful. When, of course, there has been quite a lot of criticism in terms of the rules around enforcement, because as we can see, they're so disparate, all the different rules and all the different places that you find the information. I think it's something to keep an eye on going into next year. My understanding is they are looking at this. Obviously, the Law Commission reported on this, I think, back in 2016. So it's just an area that we all need to be familiar with, but certainly to keep an eye on, because there may well be reform, who knows. In terms of any questions, I don't know if we've had any questions come through, but they will be answered via email. If you're watching the recording and you have any questions, please email events@42br.com. The recording will be available shortly, and we would be grateful for any feedback. This is actually the last webinar in our Family Autumn-Winter webinar series. We hope you have found the webinars useful. And as mentioned, we are currently putting together a programme of webinars for next year, so do watch this space. Thank you.